welcome. We are business litigators from Norton Rose Fulbright. I'm Nathan Baum, this is Veronica Kendrick, and this is Jackie Baker. We all went to Texas Law School, and we've had the pleasure of litigating with each other for the better part of the last decade. And the way that the format will work today is we're going to present on the biggest business litigation cases of 2022. Veronica will be arguing one side, Jackie will be arguing the other side, and then we'll talk about the holdings and the takeaways that we can take into 2023. And with that, I'd like to turn it over to Veronica and Jackie to introduce themselves as well.
Hi, everyone. Happy to be here. I'm Veronica Kendrick, Senior Associate in the Dallas office. As Nathan said, the three of us have been practicing together for a while. We've all been at Norton Rose Fulbright for our entire careers. Between the three of us, cover cases ranging from your everyday contract disputes to antitrust cases, healthcare disputes. So we're excited to present to all of you and be here with you today.
And hi, everyone. I'm Jackie Baker. I work with these two quite a bit, currently and in the past. And these two have worked together on one of the cases that we're covering today. So I want to give that spoiler alert.
Hopefully you all can guess which side. Ready?
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 Sure.
First case is about movie theaters. AMC Entertainment Holdings versus IPIC Gold Class Entertainment. This is an antitrust conspiracy case in which IPIC movie theaters, has anyone heard of IPIC or been to an IPIC theater? It's a very upscale boutique movie theater, and they were planning to open up a theater very close to here in Frisco, very close to an AMC theater. And so the case is about IPIC alleging that AMC engaged in conduct, attempting to drive it out of business. This case went all the way up to the Texas Supreme Court and was decided early last year. And with that, Veronica will be arguing on behalf of AMC, and Jackie will be arguing on behalf of IPIC. Veronica, go ahead. Oh, that's the holding. Okay.
And before I go character mode, just a teeny bit more context so you guys understand. IPIC was the plaintiff in the district court. AMC won summary judgment in the district court. IPIC appealed, won the appeal. AMC petitioned the Supreme Court for review, and that's where we are. So, going in character mode now. This lawsuit is the result of IPIC's years-long crusade. Yeah.
Speak up.
Okay. This lawsuit is the result of IPIC's years-long crusade to use the Texas antitrust laws as its own private shield against AMC's perfectly lawful competitive conduct. But antitrust laws don't exist to insulate those who don't wish to compete. Antitrust laws exist to promote healthy competition. IPIC claims in this case that AMC conspired with another movie theater company, Regal, to restrain trade in violation of the Texas Antitrust Act. But antitrust law tells us that conduct that is just as consistent with permissible competition as with illegal conspiracy, there we go, does not, standing alone, support an inference of antitrust conspiracy. At the summary judgment stage, an antitrust plaintiff must have evidence that tends to exclude the possibility that the alleged co-conspirators acted independently. This means that if a plaintiff is relying on only circumstantial evidence of the existence of a conspiracy, that evidence has to go further and show, for instance, that the defendant's conduct would be against its own self-interest if acting alone, but would be in its interest if acting in concert with another. At the summary judgment stage in the trial court below, IPIC's evidence failed these tests. IPIC first relies on evidence that on July 8th, 2014, AMC announced to the film studios that AMC's Frisco, Texas theater would not play the same films as a very nearby IPIC Frisco theater. And the same day, Regal announced to the film studios that Regal's Houston theater would not play the same films as a nearby IPIC Houston. But what IPIC ignores is that it was common industry practice at the time for theaters of all kinds not to play the same films as their nearby competitors. In fact, for years, AMC, Regal, and many other theaters opted not to play the same films as their nearby competitors all over the country, not just IPIC theaters. In some instances, AMC and Regal declined to play the same movies as each other's nearby theaters. This was clearly not the conduct of co-conspirators. IPIC's next piece of evidence is a group of calendar appointments and emails that show that AMC executives and Regal executives did interact occasionally. The appellate court latched onto this and called it evidence of a channel of communication that could have enabled a conspiracy. But courts have held over and over that evidence that co-conspirators had an opportunity to interact, including meetings and conversations, will not create an inference of a conspiracy without more, even when those meetings and conversations are followed by parallel conduct. So what matters under the case law is not that IPIC has evidence that AMC talked to Regal every now and then. It's that IPIC has no evidence that those conversations had anything to do with IPIC. Finally, IPIC relies on some internal analyses that AMC conducted, which showed that its decision not to play the same films as nearby theaters could result in short-term financial losses. But the evidence also shows, and the appellate court acknowledged, that those short-term losses could be outweighed by long-term benefits to theaters who don't play the same films as their competitors. The relevant test doesn't ask whether there are any economic downsides to a business's conduct. It asks whether the business's conduct only makes sense if the business is acting in concert with another. It asks whether the business is acting against its self-interest if acting alone, but in its self-interest if acting with another. IPIC's evidence just doesn't go that far. What IPIC presented at the trial court level was evidence that AMC vigorously but lawfully competed. That isn't enough under the controlling case law, and the appellate court's decision should be reversed. Thank you.
And Jackie will argue for IPIC.
May it please the court. The Court of Appeals correctly reversed summary judgment for AMC on IPIC's claim of conspiring with Regal to crush IPIC with clearances. Under Texas law, parallel business behavior is admissible circumstantial evidence for which a fact finder can infer an agreement and thus a conspiracy. But a plaintiff must also present evidence that tends to exclude the possibility that the alleged conspirators acted independently. IPIC has offered more than a scintilla of evidence of Regal and AMC's conspiracy, and this is all IPIC was required to do at the summary judgment stage. AMC and Regal are competing titans, ranked number 1 and number 2 in size in the film exhibition industry. Together, AMC and Regal announced their joint strategy not to play the same films as nearby IPIC theaters on the same day, well before either IPIC theater had opened. This can only be evidence of coordination, not coincidence. The same day and nearly identical threats simply defy innocent explanation. Second, IPIC presented evidence that AMC and Regal had illicit communications about corporate strategies. While AMC downplays the import of these communications, they were not just everyday communications between two industry participants. The subject matters of these emails and meeting agendas confirm that these were communications between two fierce competitors in the industry discussing business strategy. Third, IPIC presented evidence that AMC and Regal both knew that deciding not to play the same films playing at competing theaters could hurt their businesses. That was made all too clear when, for instance, Regal, AMC's co-conspirator, declined to play Star Wars: The Force Awakens at its Houston theater because that film was also playing at the nearby IPIC Houston. Unsurprisingly, Regal took a huge financial hit with that decision. Rational theaters acting alone simply do not refuse to play Star Wars. A reasonable jury could therefore find that AMC and Regal would only expose themselves to this sort of inexplicable, catastrophic economic loss if they did so intending to jointly drive a shared competitor out of the business. Thank you.
Thank you. And the winner was? The Texas Supreme Court reversed the Court of Appeals in favor of AMC. And Veronica and I actually worked on this case for many, many years. That is one of the takeaways here with antitrust litigation, is that it's oftentimes big. There's oftentimes lots of witnesses. There's lots of documents. The scope of discovery is very large, and that is one of the factors that companies have to understand when antitrust litigation arises. So what the court determined, as Veronica argued, is that it is the plaintiff's burden in these cases, so it would be IPIC's burden here, to present evidence that would exclude the possibility that the conspirators acted independently. And so as Veronica said, AMC's position was that AMC and Regal had acted independently. There had been no cooperation, there had been no conspiratorial conduct, and that it was then IPIC's burden to present evidence aside from calendar invites or emails referencing IPIC that would exclude the possibility that both companies acted in their independent, on independent tracks. So let's talk about some of the lessons learned. Like I said earlier, Veronica mentioned an example of an email from 2014 in her presentation, and this case was not decided by the Texas Supreme Court until 2022. So that is 8 years. We've had other antitrust business litigation cases that we've worked on together that have spanned over a decade. These cases are large, complex, there are many business issues at stake, and it's very hard to keep discovery narrow. In addition, the law in the antitrust world is not clear. There's lots of gray area. There's lots of arguments on both sides, or evidence tending to, could be argued one way or another way. It's very evidence-based, very fact-based. There's no real clear answer from the start of the case about what elements may be met or not met. This all has to get worked out through the scope of discovery. And so with that, as in-house counsel and outside counsel, we frequently advise our clients when you're talking with a competitor or about a competitor, those emails, phone calls are oftentimes the linchpin of these cases. They determine first the scope of discovery. If there are a bunch of discussions about competitors or with competitors, those emails, phone calls are all discoverable. In addition, those emails and phone calls and the substance of those communications is the linchpin in these sorts of cases, whether the standards can be met or not met. Finally, actions, a lot of times in industries, there's actions taken that are targeted at competitors to win in the marketplace. And those actions need to have a justifiable business purpose. One thing that was challenging here was, as Jackie mentioned, the decision by Regal not to play the Star Wars movie. Seems like to just somebody on the outside that is a money-losing decision in the short term. And it's very important that business decisions relating to competitors have justifiable economic reasons so that you can show the court later on that this was not an against interest behavior solely to drive a competitor out of the marketplace. Do you all have anything to add?
That about covers it.
Okay, well, let's move on to the next case, which is a trade secret protection case with also a little hint of a non-compete as well. It is CAE Integrated versus Move Technologies. This case involves a former employee, Nicholas Meisner, who went from CAE to Move. Many of his customers also switched to Move as well, and there's allegations of trade secret use and access. This case was on a preliminary injunction hearing where the preliminary injunction had been sought by the former employer, CAE, and had been denied, and the case went up to the Fifth Circuit on appeal, which is where we pick it up now. Veronica will argue for the former employer, CAE, and Jackie will argue for the new employer, Move.
Nicholas Meisner worked at CAE for 10 years, and for most of that time, he was engaged in a scheme to secretly compile a trove of CAE's most secret information. Meisner has admitted under oath that around 2009, he started saving highly confidential materials to folders on his computers that were synced to a personal cloud-based Google Drive account. He admitted that while at CAE, he amassed this folder that included confidential customer information, confidential documents detailing customer transactions, and much more, in folders that, again, were synced to his personal iCloud Drive. This was a direct violation of CAE policy. Then, after his employment with CAE ended, Mr. Meisner joined one of CAE's fiercest competitors, and in negotiating for that job, he told them that he had tons of CAE's confidential information, he could bring that information to Move, and he could help Move compete with CAE in a way that they had never been able to do before. Meisner and Move's plot to exploit CAE's confidential information was then confirmed when shortly after Meisner was hired, he sent a text message that we introduced in evidence at the preliminary injunction hearing, asking Move's CEO to ask his attorney, quote, whether the contact information and the data I collected over the years is good and I'm clear to use. Shortly thereafter, Mr. Meisner started working, and Move's CEO told him not to, quote, bombard people too quickly and to ensure an organic paper trail. Mr. Meisner responded he would be sure to create a formal paper trail to protect us. Protect them from what? From CAE finding out exactly what they were doing. This evidence, together with the evidence of the exponential success that Move was able to accomplish once Meisner joined their team, can only mean one thing. Meisner and Move together exploited Meisner's misappropriation of CAE's data to contact CAE's customers who would have been impossible for Move to locate without that access. Now, Meisner and Move have emphasized that Meisner's non-compete only required him not to be employed by a competitor for 1 year, and he waited that 1 year before going to Move. But that 1 year limit didn't apply to Meisner's use, collection, sharing, and exploitation of CAE's trade secrets. Because CAE's evidence demonstrates a substantial likelihood of success on its trade secret misappropriation claim, the preliminary injunction should have issued. Thank you.
After CAE hired Nicholas Meisner, he halted his career and honored his 1 year non-solicitation agreement. Yet, over a year later, when Meisner started working for Move, an upstart competitor of CAE, the company decided to, quote, go to war with Move, suing the company and Meisner and asking the court to grant an indefinite customer solicitation injunction pending trial. When asking for this injunction, CAE initially pinned its hopes on accusations surrounding documents stored on Meisner's personal MacBook computer and Google Drive, which CAE had known about for years and which CAE, not Meisner, still had possession of at the time. At bottom, this lawsuit was filed based on a 5-year-old snapshot of Meisner's files that CAE took when transferring his personal computer over to a work computer. As the evidence developed, however, it became clear that Meisner had deleted those old files before starting at Move, and he had relinquished access to the Google Drive that previously contained them. Indeed, at the injunction hearing, CAE produced no evidence that Meisner or Move had disclosed or used any alleged trade secret files. Forensic analysis confirmed his testimony that before he arrived at Move, Meisner had deleted the customer-specific sales information and transactional documents CAE accuses him of taking. Forensics also revealed no overlap between Move's files and the 5-year-old snapshot taken by CAE. Given these facts, CAE opted to pivot and argue instead that misappropriation could be inferred based on Move's rapid success in the industry, asking the court to enjoin Meisner and Move based on the customer identities Meisner had carried in his head when he left CAE, and that this use of confidential files on Meisner's Google Drive could also be inferred from Move's business successes following Meisner's employment. But under federal and state trade secret statutes, an employee's mere knowledge cannot be the sole basis for an injunction, nor can Move's industry success provide sufficient evidence of use. As such, the district court was well within its discretion to deny the requested injunction based on this inferential argument alone.
Okay, and the case was decided by the Fifth Circuit in favor of Jackie and Move, the new employer, affirming the denial of the requests for preliminary injunction. And the reasons here were very much based on the forensic evidence that had been presented by Move, as you heard from Jackie. The forensic evidence showed that Meisner had never accessed or used the information at issue, and that he could instead rely upon, and was permitted to rely upon, his own personal knowledge about who his customers were in the past. He was not required to delete that information from his head. And that this inference argument, just because the new company did well or had sales with some of the prior customers, was not enough to infer that those transactions were due to Meisner having accessed or used information from his prior employer. Some of the takeaways here. This case took 6 months from the initiation of the litigation until the actual preliminary injunction hearing, in which there was discovery, forensic analysis, and the like. It was a full 2-day evidentiary hearing at the trial court. And this goes to show that these cases can get large and have lots of discovery right from the start. This, usually in a business litigation case, 6 months in, you may still be at the motion to dismiss stage where no discovery has occurred, but in these preliminary injunction employer versus employee fights or non-compete issues, the discovery really kicks off right from the start. The other thing that Move did here that was particularly helpful was it engaged in forensic analysis of the devices. And this forensic analysis these days can show when files were accessed, when they were created, when they were modified. A lot more information in a trade secret case that wasn't available in the past, that the court really relied on here to answer these arguments of inferences and potentially bad conduct, was that there was forensic analysis showing that Meisner had not accessed, had not modified any of the files, had not changed any of the underlying information. Companies should engage in this sort of forensic analysis in these situations very early on. This was also a situation where Meisner had actually not chosen to leave CAE, but had been fired. And so the company and companies should have a process for post-termination dealing with devices, how the information is stored, what information can be determined from those devices in case the employee goes and works for a competitor. You can go back, a year later they were able to go back in time and see what information was on the devices and was on the Google Cloud. The other important takeaway here is that even though this employee had a non-compete, he had a confidentiality agreement, he had a non-disclosure agreement, he had a non-solicitation agreement, still what was in his head was completely fine, and he was free to use that information in this instance. And that's a very important, a very important ruling here from the Fifth Circuit.
Can I add one thing before we move on?
Of course.
I would just say that in our experience, this type of forensic analysis and looking at metadata is so important. If a company is considering bringing a lawsuit, even do that first, because a lot of times we latch onto things that documents say and who received them, but we don't go that extra step of, well, you sent that email, but the person on the other end never opened it. Or, oh, we think this document shows exactly what we want it to, happened when we said it did, but if you look at the metadata, it shows that it was actually dated on a different date that proves the other side's case. So any internal analysis to the extent cost and time allow of metadata and forensics is a really helpful tool now in business litigation.
One other aspect we wanted to talk about, and there is a presentation later today on non-competes, is that the Federal Trade Commission has recently proposed a new rule that potentially may ban the use of non-competes in an employer-employee context. There are a couple of important takeaways from this, is that in this instance, the case still would have happened even without a non-compete. You can still include in employee agreements confidentiality provisions, NDAs, non-solicitations. And another important clause that you may consider adding into your agreements is a destruction clause that says that the employee has to return or destroy all information at the conclusion of their employment. And that clause may assist if this Federal Trade Commission rule does actually pass, that will protect your company in the case that an employee goes to a competitor. Yes?
Do you have any advice in light of the FTC proposal? Do you have any advice to companies who are looking to hire employees who may or may not be subject to another company's non-compete? It seems like you've got competing risks, right? Tortious interference on the one hand versus this violation here.
So what we would recommend there is for the new company to add a provision in the employment agreements that specifically says that the employee certifies, and it is a condition of employment, that they do not have any prior non-competes that would potentially be triggered by moving to the new employer. That oftentimes helps on a tortious interference claim, for example, where the allegation is that the new company influenced the employee to break their non-compete, that if you have a certification in the employment agreement, that shows that the new employer acted in good faith.
What about requesting to review the prior employment agreement?
The issue there is that there could be other information in the employment agreement besides the non-compete that the new company is not entitled to see. So we've seen is that some companies will establish a process whereby perhaps an in-house counsel that is not involved in the daily transactions, that is kind of separate, will conduct that review and then will immediately destroy the document. And so that there's some level of protection, but yet there's no risk that the new company is using information from the prior company. Do you all have anything to add on those two?
Nope. Just the only other thing we've seen is that, or sending like a partially redacted version of that agreement, asking the new employee to make sure that confidential information is redacted, if there's sales territories or that sort of information in the agreement itself. But yeah.
All right, final case, and I know it's almost lunchtime, so apologies in advance, but we've got a insurance dispute involving Terry Black's Barbecue. The case is about the governor's order that precluded Terry Black's from using their dining room during the pandemic, and Terry Black's sought coverage from their insurance provider for that business disruption. Veronica will be arguing for the restaurant, Terry Black's. Jackie will be arguing for the insurance company. This case went up to the Fifth Circuit early last year. So Veronica, take it away.
All right. Terry Black's trusted the respondent to provide insurance coverage for interruptions to Terry Black's business. And respondent promised to provide that coverage. But now respondent has put its own self-interest ahead of the struggling small businesses who already suffered so much in the pandemic's wake. Terry Black's business insurance policy with respondent specifically promised that respondent would pay Terry Black's for, quote, actual losses of business income sustained during suspension of operations caused by direct physical loss of or damage to property at Terry Black's restaurant premises. Nothing could more clearly fit these circumstances than the realities of the COVID-19 pandemic, when Terry Black's was forced to close its physical locations, particularly its indoor space. Loss of property, the phrase actually used in the policy, clearly encompasses government-ordered prohibitions on in-person dining at Terry Black's property. Respondent also promised to provide coverage to Terry Black's for its business losses caused by suspension of operations due to, quote, an order of civil authority resulting from the actual or alleged exposure of the premises to a contagious or infectious disease. Again, this provision of the policy clearly covers the many civil authority orders that were a hallmark of the pandemic. The policy language is clear. Coverage is triggered by the actual or alleged exposure of the premises to contagious disease. The district court incorrectly concluded that exposure means presence of contagious disease on the premises. But the standard dictionary definition of exposure means not shielded or protected. The civil orders were issued for precisely the reason that the public, and most specifically businesses like restaurants, were not shielded or protected from COVID-19. Respondent made these promises to Terry Black's and other businesses who entrust respondents with their business interruption insurance. Now, following the most unprecedented business interruption of the modern era, respondent is trying to get out of these promises any way it can. The court should hold respondent to its word. Thank you.
The district court correctly concluded that the policies at issue did not cover Terry Black's losses. In Texas, insurance policies are interpreted by the same principles as contract construction. The words of the policy are given their ordinary and generally accepted meaning, unless the policy shows the words were meant in a technical or different sense. All parts of the policy are read together, and courts must give effect to each word, clause, and sentence. First, the district court correctly concluded that there was no coverage under the business income and extra expense provision because the plain meaning of a physical loss requires some distinct, demonstrable, physical alteration of the property. Terry Black's has failed to allege any tangible alteration or deprivation of its property. Nothing physical or tangible happened to its restaurants at all. In fact, Terry Black's had ownership of, access to, and the ability to use all physical parts of its restaurant at all times. And importantly, the prohibition of dine-in services did nothing to physically deprive Terry Black's of any property at its restaurant. The context of this provision also supports this conclusion. The business income and extra expense provision provides coverage only for a period of restoration, which is defined as the time needed to repair, rebuild, or replace the lost or damaged property. This period necessarily contemplates a tangible alteration to the property that requires repair, rebuilding, or replacement. In contrast, the prohibition on dine-in services does not require Terry Black's to repair, rebuild, or replace any property at its restaurants. Finally, Terry Black's argument regarding the loss of use of its dining rooms is also unpersuasive. The provision unambiguously requires loss of property, not the loss of use of property. Terry Black's tries to stretch coverage to include the loss of use of its restaurants for their intended purpose. But Terry Black's argument reads far more words into the provisions than are actually there. As for the restaurant extension and endorsement provision, the district court likewise correctly concluded that there was no coverage because the civil authority orders were issued as a result of the pandemic, not the actual or alleged exposure of the described premises to the pandemic. The key here is that the requirement that the civil authority orders resulted from Terry Black's actual or alleged exposure to a contagious disease. The plain meaning of resulting from is causation, and Terry Black's has failed to allege any causal connection between the restaurant's exposure to a contagious disease and the civil authority's suspension of Terry Black's operation. Thus, its losses are not covered by the REE provision either.
Thank you. And the winner was the insurance company. The Fifth Circuit ultimately affirmed the judgment on the pleadings in favor of the insurance company against the restaurant. The reasoning was that the court really focused on the language in the policy. That was the key. The exact text of the policy, much like any other contract, was what governed here, even in the face of very sympathetic facts from the restaurant. The words physical loss of property meant a tangible alteration or deprivation of the property was required. The loss of use of the property for the particular services was not enough. The example that the court used here was a scooter and a law that says that scooters cannot be used on sidewalks would not be enough to preclude someone using a scooter on some other land, just not on a sidewalk. The second key holding was that the provisions in the contract requiring a causal connection between the property's exposure and the civil authority order did not apply because the civil authority order that required the closed dining rooms was not the result of Terry Black's itself exposure to COVID-19, which is what the words of the policy said. Lessons learned from the Terry Black's case can be applied even outside the insurance context. That even where there are good facts or bad facts, the courts are, in business cases, are relying on the language of the contracts, the language of the insurance policies. That is the number one key when seeing how these cases come out. Even extraordinary facts like here weren't enough to override the plain language of the contract. Anything else to add?
No, just again an emphasis on the Fifth Circuit, Supreme Court, Texas Supreme Court cases from the past year. Obviously there was a lot of COVID-19 related litigation, but the holdings about strict interpretation will impact every industry and every situation. We use this example because, again, it's the most extreme set of circumstances, and even then, courts were not willing to even let this get to summary judgment. There was no investigation. It was just, your language doesn't say that, you lose.
Yeah. Dismissed on the pleadings, so super early.
All right, that is our presentation. We'd be happy to answer any questions that you have. Well, thank you all very much again.
Thank you.